Hi, hello, good evening, everyone. Hello, क्या हाल चाल है? All well? I hope all of you are doing good. I'm good. I'm good here. I'm a little disappointed. I'm a little disappointed with the numbers. We don't even have 100 students attending this session live. Call your friends immediately. Webber Bhaiya is not going to start the session unless there are 100 students. Come on here. Yes, I did. I did listen to Watermelon Sugar. I did. And I realized that it's a song that is used in a lot of Instagram reels. So I had previously heard it, but I never even cared for the lyrics and all. But yes, I did listen to Watermelon Sugar. Good evening, everyone. Good evening. Bula yaar, call all your friends. Ask them to join immediately. I'm not gonna start unless we touch at least 100. 16 more to go. I'll not even give motivational gyan unless we reach 100. Meg asks, do you invest in stock market? If yes, what is your favorite stock? uh, Meg, no, I don't invest in stock markets. I have to, but and I don't really have much knowledge. It's always subject to market risks. Please read the, you know, uh, please read the contract before getting into it. अच्छा मेरे आते ही स्ट्रेस चला जाता है वाह क्या बात है कमान यार नंबर ही नहीं बढ़ रहा है क्या 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 चल रहा है ये why are your friends not joining what is the problem अरे थैंक यू खुशी थैंक यू सो मच फॉर योर लवली कमेंट Riddhi, don't be nervous. What you're getting, you will definitely score more than what you're scoring right now. So don't worry because the moment you start worrying, everything goes haywire. See, remember the last class that I took, the last top 150 GK current affairs, current events wala class. What did I tell? What did we discuss in that class? It was very simple that shut your brain from all these thoughts that are coming to your head and just focus on what you're supposed to do right now. और कुछ मत करो बस जो करना है वो करो लास्ट के कुछ दिनों में you just have to give your best do that don't think about what is going to happen what is not going to happen all of it really does not matter at this moment I know it's difficult and when I was at your age I would also do the same thing but that's a mistake that or that is something that is something which you learn from me. Are Yash says Bahubali of IMS is here. So we have 100 now. Now I'm happy. Now I'm happy that we have 100. Now I can start with all my enthusiasm. Don't panic. See, one thing for sure is don't panic. It's not that only you are panicking and you are under stress. Everyone is under stress. Trust me. Important thing would be on the day of the CLAT examination, please leave for your set. Please leave for your center, keeping in hand 2 to 3 hours. Sorry, keeping 2 to 3 hours in your hand. That is going to be very, very crucial. And please, one very important piece of advice that I can give to all of you attending this session is now whatever 3-4 mocks that you would be taking, make sure that you put your face mask, face shield. If you're going to wear gloves, sab pehen ke, then you take your mocks. Like give yourself as closest experience of the actual CLAT exam that you're going to face there. make sure that you do that for the next 2 to 3 mocks in the last few days, in the last couple of days that we have left. This is going, trust me, if you do this, that day having that face shield or having that mask for that 2 hours continuously, and maybe that gloves or whatever you're going to wear or keep with you, or if you're not wearing the gloves and using sanitizer all the time, that is not going to be something which is new for you. And as much as we can avoid bringing an element of surprise during that 2 hours of actual CLAT examination, trust me, you'll be good. Yes, please start practicing on OMR sheets. And again, one very important tip that I can give to all of you attending the session for the OMR thing is, use like, how do I put it? Circle from the edges, right? So start marking from the edges and then just come in between. Don't go from between towards the end, because that way we get very conscious about whether we are going out of the oval or not. So you don't want to be doing that. So make sure that you start practicing with your OMRs as well. How to save time in OMR? Okay, Harsh. So OMR के लिए, like I said, एक tips वाला video बनाया था मैंने, जिसपे कि I had told कि अब जैसे तुम्हारे पास 2 पेपर है, 2 leaflets है, and that 2 leaflets has say 20 questions, और तुमने वो 20 questions में से 14 questions mark कर लिया है, and you have left 6 questions. So from that question, from that question onwards, so say 1 to 20, तुमने already 2 leaflets solve कर लिए, तो उसको OMR में like utar do, like mark all those answers, all those 14 answers, and leave those 6 which you have not marked. So this will save your time, and most importantly, it will give you that 30 seconds ka break to your brain from reading. That is something which is going to be very crucial, and there would not be a sense of panic that I have done the entire paper, but I have not marked anything on the OMR. So that is something which we tend to become very panicky at the end, and you might actually end up marking all the answers incorrectly, because कभी भी एक भी गलत हो गया ना, तो फिर वो पूरा ही पेपर खराब हो जाएगा. So don't do that. 2 leaflet जितना solve किया उसको OMR पे डालो, and then go to the next leaflet. ठीक है, चलो. So अभी start करते हैं अपना legal aptitude का practice session, right? 3 set of passages है, मैंने भी देखा नहीं है. All right. So I am also going to be taking it just as if seriously मैंने नहीं देखा है, because I wanted it to be I wanted it to solve with you people and let you show that even I would be making certain mistakes when I would be solving it live with all of you. ठीक है, तो अभी क्या है कि start करते हैं. We'll start this practice sets now, and you people can simultaneously keep answering in the comment box. I'm looking at the comment section all the time. Okay. Important thing is, please write the question number when you answer. So if we are doing question number 1, then write 1 and then your answer option. Of course, like, take as many offline mocks as possible for CLAT now. Don't take online mocks. And for all the IMS students who are attending this session, there are 3 more mocks that are in transit. So you will be receiving those mocks. So don't worry. We have already sent it and it is in transit, and you will receive, I think 23, 24 and 25. You'll receive those mocks in time. Don't worry about it. Yes. Modi ji, please start practicing in OMR sheets from now itself. It would be good. Okay, chalo. All right. So here comes the first passage. Again, before I come to the passage, let me again give you a very brief about how I approach legal reasoning section. If I look at a particular concept that I already know, and that passage is based on that concept which I have certain knowledge about, I don't spend a lot of time reading that passage because I know that I already have some idea about this passage. So what I do is I quickly skim through the passage and thereafter I straight away go to the questions. All right. All right. So now we come to the first passage. And the first passage talks about consensus ad idem in contracts law. Consensus ad idem, meeting of the minds over the same thing in the same sense. Okay, this is exactly what they have said. Meeting of the minds of all the persons, contractual obligations, agreement is required element for a contract to be enforceable. No consensus, no contract. Court has to examine the full scope of the agreement to find out whether the parties fully understand enough about the contract and a meeting of the mind is established. No single test decides whether both the parties understood the terms or not, blah, blah, blah. When it's suggested that there's been a breach of contract, the alleged breaching party might claim there never was a contract by suggesting that there was no certainty or meeting of minds about the contract subject. Because sometimes contracts lack precision to allow room for flexibility in the business dealings. This leaves the court in the position of examining other dealings between the parties involved to figure out which parties' intentions were when entering into the contract. Okay, fine. So basically, this passage is talking about meeting of minds. We know about it. We have read it in contracts. हमको इतना ज़्यादा in depth इसको नहीं देखना. ठीक है? Now let us quickly come to the question. So this is the first question that we are looking at. Okay, fair enough. I've understood the question. लो यार मैंने कैमरा ऑफ कर दिया. देख लो, फटाफट पढ़ लो. नहीं यार वो शिफ्ट नहीं हो रहा है यार, यूट्यूब पे शिफ्ट नहीं हो पा रहा है. दैट्स द प्रॉब्लम. Please write the question number and then your answer. Devya, Vardhan, Vanshika, Riddhi, please write question number. Good. Parth, write the question number and then your answer option. Okay, ठीक है. Fair enough. So now let us understand what the correct answer should be. See, I have not even read the options so far. I have not. But after reading what the question is talking about, I have made an understanding that what my decision should be. And then I'll be finding that option amongst A, B, and C, D. A, B, C, and D. All right. Now, majority of you have answered B. Is not entitled to a replacement. This is absolutely wrong. He is entitled to a replacement. Why? What they're discussing is exquisite imported liquor. All right. What is exquisite? This is ambiguous. Whether 12-year-old is exquisite or 18-year-old is more exquisite. It was never clear. So what she had offered was a Chivas Regal 12-year-old whiskey to Dharmesh at 37,000, whereas there was an 18-year-old whiskey of Chivas Regal whiskey itself, which is of course more aged and therefore more exquisite. So what he was thinking, what Dharmesh was, sorry, and see, the correct answer is C. So, what Dharmesh was thinking when he entered into the contract was that he would be getting the most exquisite one for which he's paying 37,000, right? But what he later on realized that he did not get the most exquisite one. There was even a better quality whiskey than the 12-year-old Shivas Regal. So what was there in Dharmesh's mind was something else, and what was in Divya's mind was something else. So you can't say that there is a meeting of mind in this case. And therefore, the correct answer is C. See, and this is why I always tell you, rather than once you have read the question, rather than reading the options, firstly formulate what your answer should be and then start finding out which option says so. That is why when I looked at option B, I told you that this is absolutely wrong because my mind had already made up the answer that there is no meeting of mind in this case. What Dharmesh was thinking was different, and what Divya had offered and given and what she was thinking was absolutely different. Chalo, koi baat nahi. Moving on to the next question. Hi, Krisha. Hi, hello. So we are discussing a passage which is based on consensus ad idem. Uh, nahi, so what you're saying about most exquisite, and that is where the ambiguity lies, Modi ji. That is where the ambiguity lies. What is most exquisite? The moment there is an ambiguity, there cannot be a meeting of minds. Correct. So this is very simple. This definitely does not amount to meeting of the minds. So we already know, and majority of you have answered C correctly, which is absolutely correct. Very good. Amazing. ठीक है? Good. Simple है. One, they were thinking, so one party thought about October, the other party thought about December. There is no meeting of minds. So two had to be correct, right? Secondly, they're talking about ambiguity in peerless and the ship being referred to, right? And because there is an ambiguity, there is no consensus addendum. One also goes, therefore C is the correct answer. See, again, what is ambiguity? Ambiguity is something which you have the option of making more clear. Now, supposedly, when I say a bat, a cricket bat, what cricket bat? What is the weight of that cricket bat? Correct. What willow? What willow are you using? Are you using an English willow? Are you using a Kashmir willow? You don't say, and you just say a cricket bat. Now, this is where the ambiguity lies. So, in my mind, when I'm purchasing that bat from you, I might be thinking that what you're offering me is a Kashmir willow, whereas in your mind, what you have in your mind is that you would be giving me a bat made of English willow. No consensus added in, right? Question number 3. Yes, all the questions are new questions. You will have to read them. So the question that they are asking to you here is, which of the following the courts are most likely to decide? Are the courts going to say that this is a valid contract, or are the courts going to say or hold plaintiffs liable for the value of the goods? That is what you have to decide. Okay, so it has to be D, right? Reason being, Sundi is actually the innocent third party. So he himself is the innocent third party. So two is gone. There is not a valid contract between Lindsay and Berglund despite the mistake of identity, because there is no consensus added up. Neither one or two has to be correct. No. This is wrong. It has to be D. One minute. Let us have a look at what they're explaining. No contract had been concluded between Lindsay and Blenkern, correct? And Blenkern had no title to the goods, correct? It was deemed impossible for Sundi to hold a title. So therefore, Sundi was therefore held liable to the plaintiffs for the value of the goods. एक मिनट, अब देखो ये थोड़ा कंफ्यूजिंग क्वेश्चन है, जो गलत हुआ है. Let us not waste time on this. ठीक है, गलत हुआ जाने दो. Let us move ahead. We will not be wasting our time over a question which we are not very sure of. Question number 4 पे आओ. Consider that Blenkiron and Co. did not exist and the rope contracted under the name Lindsay and Co. received goods on credit and sold them to the defendant in good faith. Which of the following is then the court most likely to hold on the discovery of fraud? Okay, simple question. There is a discovery of fraud. What happens when a contract is entered on the basis of fraud? Void or voidable? Void or voidable? जल्दी बताओ, जल्दी जल्दी. Voidable? Hey, void minal? Voidable. So we already know that fraud है तो voidable होना चाहिए, right? Option B tells us the same thing. आंख बंद करो and अच्छा, there was, okay. So B is definitely correct, and they say A, the innocent third party had acquired a title and the contract stood valid. At best, the contract can be held voidable for fraud but not on the basis, acha, हाँ ठीक है यार, ठीक है, correct, my mistake. So as long as it's voidable, so unless the person who has the power to avoid it, that voidable agreement would still be valid, right? And that is what option A is talking about. That was my mistake. I did not read it completely. Okay, so therefore A and B, both of them are correct. Question number 5th pair. Okay, so I'm not going to make the same mistake again in this question, which I did in the last one. This is again a very simple question, straightforward question. Question number 5. Ronak, Ishika, please write question number. Krisha, please write question number and then your answer option. Correct. Absolutely. Absolutely. D, Delhi is correct. See, it's correct. So yes, there is. So the fact itself discloses that both the parties do not agree to the same thing. So there was no meeting of minds. B is correct. And contract is not valid as in the absence of consensus ad idem, the contract itself is void ab initio, which is also correct. So B and C, both of them are correct. And option D seems to be perfect. Question number 6. Okay, so they have given some additional principle here, which we'll have to read. So what is a subjective approach? It is simple, where you have your scope of interpretations. Okay. When you have the scope of interpretations, that is where you say that it is a subjective approach that the court is following. Now, in this fact, what they're saying is a monetary reward was given for arrest and conviction of persons responsible for murder of 2 police officers, right? And in this case, this Tiwari was arrested in connection with the murders itself. And he made statements to the police about the murders and which led to the conviction of other people. Now, Tiwari was released and subsequently claimed the reward. All right. Now, what does your subjective approach here tells you? His intention was to enter into a legal relationship so as to claim the money, or was his intention to actually get an acquittal for himself? So defendant definitely did not act in a way which is consistent with an individual who intended to enter into a legal relationship with the police or the government, right? His real intention was to prove his innocence rather than accepting the money. So therefore 2 is something which goes correct, right? So 6B is the correct answer, Bombay. All right. So we are done with one passage. We made one mistake. There was one oversight, but rest out of 6, we were able to solve 5 very correctly. Good. Like this is a good accuracy. Now let us quickly come to the second passage. Okay, so they are talking about Evidence Act, Section 3. I think this we'll have to read. So I think this we'll have to read. So let us do the reading carefully, yet very quickly. Okay, so we are done reading section 191 of IPC, which gives us the definition of false evidence. And 192 talks about fabricating the false evidence. So 191 says, one who is legally bound by an oath or an express provision of law to state the truth, but yet does not speak the truth. That is giving of false evidence. Fabricating false evidence requires three elements. Circumstance must exist. You make a false entry or a document. Intent should be that it appears or it would appear in an evidence, in a judicial proceeding, or before a public servant, or before an arbitrator, and because of which, an erroneous opinion, a wrong opinion has been made by the public servant. Right? So this is what is 191 and 192. अरे रोनी कभी क्वेश्चन आया ही नहीं, तुम कहां से आंसर करती है? Okay, then we come to the second part of it. Difference between giving false evidence and fabricating false evidence. ठीक है, इसको quickly देख लेते हैं. See, ideally, because we are doing this in a PPT format and I can't jump to the next passage. Otherwise, if this would have been an actual passage in the CLAT paper, I would have not solved it right away. I would have actually looked at the third passage and would have taken a call whether that third passage is something which is easier for me to go ahead with or is even more difficult or of the same level. If it would have been of an easier level, then I would have solved the third passage prior to solving or reading this. Both offense requires mens rea. One requires general intent, other requires particular intent. Fair enough. Okay, I think we have gotten it. What's erroneous? Erroneous is error. Erroneous means some error that has been caused. Your opinion has an error because somebody gave a false, statement or fabricated certain things, because of which the opinion that you have formed is incorrect. So, for example, I give you a bill, an invoice. I know I have fabricated that invoice where the actual amount was 8,000, but I added one in front of 8, so it became 18,000. So the opinion that you have formed on that basis is erroneous because what you are looking at, what the piece of paper that you are looking at is a fabricated, document. So let us come quickly to the question. Okay, so we have to decide the liability of Lewis. Very simple here. So what should be the correct answer to question number 7? Perfect. Perfect. Majority of you have answered it correctly. C should be the correct answer. A and B, we can, like, our common sense itself says that he is liable, right? He's a friend and he knowingly tells, knowingly fully what under oath he's saying something which is wrong. So he cannot be not liable, right? So A and B goes. C and D can choose karna hai. D is more factual. C is something which is closer to the principle, and C is the correct answer for us. All right, we come to question number 8. No, Meg, you can't use analog stopwatch or something of that sort. Okay, ये facts जो है ना थोड़ा सा missing लग रहा है. They would often exchange their dash. I don't know what. And however, in the final year, Maya lost her if and was caught selling drugs. What if? हाँ, exactly. थोड़ा सा. So again, this is a question which would be worthy enough of a challenge in a final, CLAT paper. But ठीक है, let us try to make some sense out of it. So what should be the correct answer? Priya states that the handwriting is not of Maya, as Maya has used her left hand, even though she's a right-handed individual. So all right, I understand. ठीक है, मतलब we did make a mistake, where you know it is it is not mentioned in the passage anywhere whether Priya, whatever Priya has stated, she has stated with a bad intent. See, remember passage में दिया हुआ था that mens rea is important, right? So यहाँ कोई general intent भी दिख नहीं रहा है, because you can't show for sure that she knew that it was not left-handed or it was right-handed. The passage is very unclear about it. So the better option, yes, was to go with none of the above. All right, we come to question number 9. Okay, sorry. So what should be the correct answer to question number 9? And yes, the correct answer is B. As an interpreter, as a translator, it is his responsibility that he does it fairly of all the documents and the statements that he has made. So he has done a fabrication. Though अब यहाँ पे question ये नहीं है कि whether he has okay, has zero given false evidence. ठीक है. So since he has lied, so the point is, the question is, has he given false evidence? The answer is yes. Why? Because he has lied on the certificate. He has lied on the certificate. It definitely amounts to fabrication, but it is definitely also a false evidence because it has gone to court, right? Question number 10. Okay, so majority of you people are saying option C, which is absolutely correct. Very good. Perfect. ठीक है. Moving on to the next question. Please use elimination as much as possible, but while getting to a point where uh, while getting to a point where we have to choose or we have to eliminate, we'll have to see कि पहले हमको आंसर पता है कि नहीं पता है. If we are not sure of the answer, then we come to elimination. If you are very sure, then don't waste time in eliminating the options. All right, so the question is, Miranda is convicted in the act of stealing his watch, right? So what is it? Is it fabricating evidence? Is it false statement? Or is it both? And majority of you are saying B or D. The confusion is between B or D. So the correct answer is B. Because see, in order to make me liable for false statement, you will have to prove or show that I did make a false statement in upon oath in the court, which the facts do not disclose. That conviction could have just happened on the basis of other materials that might have been found out. That is not very sure of as according to the facts that has been given. So I will not be concocting that fact. Let us, the idea is, let us not create our own facts for that matter. What is fabricating? Fabricating is manipulating. किसी चीज को मैनिपुलेट करना, फॉल्सिफाई करना. करेक्ट. कैट. फैब्रिकेटिंग इज फॉल्सिफाई करना, किसी चीज को मैनिपुलेट करना. All right, so we come to question number 12 now. The option seems very weird. So she has lied in the court about overhearing Army's plan to commit the crime. To help a friend, Darling knowingly fully well Army committed a certain crime, lied in the court. That does amount to false statement. She should be liable. Is liable, and she fully knew well that she had not overheard any such conversation. Makes no sense. She had not overheard any such conversation, had the knowledge that Army had committed the crime, and hence she is not liable. I think it should be D, Delhi, but they are giving B. I still haven't gotten it. I still, I'm not sure. I don't know. ठीक है मतलब. Webber, like I said, I don't understand this. See, one, it is saying that option C is saying that hence she is not liable. So not liable तो हो नहीं सकता है. Lied in court. इससे पहले तो यही पता चल रहा है कि there has to be some liability. So option C is eliminated. Option A is also eliminated. Then we had to choose between B or D. She fully knew well that she had not overheard any such conversation. Oh, I got it. Arey yaar. See, the mistake is not reading the commas. There is a comma here. Lied in court about overhearing army's plan to commit the crime. But in reality, this is the lie. She knows fully well that army has committed a crime. That is her knowledge. That is correct. But the lie in the court is overhearing army's plan to commit the crime. This is the lie. And she fully knew that she had not overheard any such conversation. That is why B is the correct answer. This was a tricky one. Not a tricky one, it just required you to read it a little properly. Yes. It was a made up lie. That is why, B is the correct answer and not B. Okay, I realize my mistake. All right. So now we come to the next passage. Question number 13 to 18, which we need to complete in another, say, what, five minutes. Okay, so this is talking about Article 14, right? Article 14 of the Indian Constitution talks about right to equality. We know this. We have read this. Correct. So we will not be spending a lot of time reading this. Guiding principle is all persons or things similarly circumstanced shall be treated alike, both with privileges and liabilities. Equality should be amongst equals. Persons may be classified into groups and they may be treated differently. Forbids class legislation, does not forbid classification. All right. So if you people have attended my constitution classes, you would be able to know that this is talking about the two tests. Test for permissible classification. Two conditions must be fulfilled, right? तो अभी चलते हैं next part पे. Right. So they are saying that the classification must be founded on an intelligible differentia which distinguishes persons which are grouped together from others left out, and it should have a rational nexus with the objective that you are trying to achieve. So you create a classification, there should be some mind that you have applied behind that classification. And second, they're saying that there has to be a rational nexus between the classification and what objective are you trying to achieve. Okay. They must have given अच्छा अनवर अली सरकार का केस दिया है, and then they have given मनेका गांधी's केस. ठीक है, काठी रानी रावत नहीं दिया है. Okay. Chalo, let us actually come to the questions now and see whether we can solve them or not. The questions are not going to be that difficult as what the passage is. Were caught stealing oil from a factory over. So now you have to decide their liability. Like you have to decide what the High Court of Jumri Talaiya is going to say in this case. All right. So majority of you say B is the correct answer. However, the correct answer is option A. I'll tell you why. So let me actually close my video. Dekho, state government may so try such offences or classes of offences or classes of case as the government may by general or special order in writing direct. So they have not categorized it already. They have not said that what kind of cases are we or are they going to, say for example, they say offenses against women, or say offenses in a matrimonial relationship, offenses against the government. They have not categorized that what are the classes of offenses that they are going to send for special, they are going to refer to the special courts for speedier trial. So this is where the ambiguity lies. ये arbitrary हो गया. अब वो government को मन क्या कहता ठीक है, normal theft को भी you have to send them. So in this particular case, we'll be sending this matter of theft also to special court. But in a similar second theft case is not sent to special court. That is where your right to equality is being violated. ठीक है? All right, moving on to question number 14. So this is actually Maneka Gandhi's case, right? Maneka Gandhi's name has been replaced with Miss Katrina. So what should be the answer to question number 14? So let us eliminate. This is definitely violative because there was no answer provided, right? And you have arbitrary powers to do this. So it has to be that there was some violation. Has the right to know why they are being discriminated is the reason, or you can say this is the rationale. But legal answer is something which is C. But nahi, they have gone with option B only. This is actually a close one between B and C. B was more factually, it was more rational के basis पे था. It confers vague and undefined power to the passport authorities. No, the question में दिया है ना, the power vests with them. Section 10, clause 3, subclause C. In public interest, they can impound her passport. So what is public interest? Is something which is a little vague and undefined. But ठीक है, अगर हम वैसे ना भी देखें, then we say that no reasonable justification has been provided. That for sure is correct. But reasonable justification नहीं provide किया, इसलिए violative of Article 14. पता नहीं यार, I don't agree. This is very subjective. देखो दीदी, this is what exactly I said. मेरे से भी गलतियां होंगी. Even I would not agree with the answers all the time, and so would you not agree with the answers all the time. The good thing is, for the majority of the questions, all of us have been answering the correct answers. All right. So ठीक है, कुछ questions में गलतियां होंगी, उसके लिए इतना परेशान नहीं होना है. Let us come to the next question. Okay, so what should be the correct answer as according to you? You people are saying option A. And the correct answer is option B. This is violative. Why is it violative? So the only reason why you can say a division of pensioners into two. So there are two kinds of pensioners that they have categorized, and they are saying that there's no rational principle, because a difference of 4 days in the matter of retirement could have a traumatic effect. Arbitrary and unprincipled, as there was no acceptable or pervasive reason in its favor. The said classification had no rational nexus with the objective sought to be achieved. एक मिनट, तो ऐसे देखते हैं. क्लासिफिकेशन हुआ. The classification is pensioners who retired after 31st March 1979 and pensioners who retired prior to 31st March 1979. Now this liberalized pension scheme that they have given to people and have kept in the first category, like after 31st March 1979, and have not considered people who retired like very few days or few months ago. What is the rationale that is there? So this is a cutoff date, right? 31st March 1979 is a cutoff date. Why is this a cutoff date? The problem is all the people who retired in 1979 from say 1st Jan to 30th March, they are left out now. And what is the rationale? It's a new scheme, I accept. But what rationale is there behind leaving these leaving all these people who retired between 1st Jan to 30th March. कोई rational नहीं है. And that is why, you say that this is violative, because classification test fulfill हुआ, but rational test जो है वो fulfill नहीं हुआ. नहीं, I think the question was pretty clear. No, so अरे कैसे C होगा? If there is no rational nexus, then the two test में एक element तो fulfill नहीं हुआ ना, तो Article 14 violation हो गया. If in order to Article 14 not being violated, you have to see two things. The classification should be there, and that classification should be based on some intelligible, like on the basis of some application of mind. And second, there should be a nexus between that classification and what objective are you trying to achieve. But if the objective what you're trying to achieve has no nexus, has no relation with the classification, so you have not justified why you have left certain people out and why you have included certain people's in. In that case, you say that since second part has been is not fulfilled, the second test of Article 14 is not fulfilled. Therefore, you go ahead and say that there is a violation of Article 14. Question number 16. A scheme of prevention of crime against women also provided for two categories of women in the prison system. Prisoners guilty of crime against women, and second, prisoners who are not guilty of crime against women. So the correct answer is option A. This is not violative. And see, why I completely agree with this, or what caused a confusion in my mind, was two categories of women in the prison system. One, so these women are either guilty of crime against women, and second, who are not guilty of crime against women. So you segregate them. You keep 1 and 2. Why do you keep women prisoners or prisoners who are guilty of crime against women separately? Is because they become a threat to the others. That's the rational nexus behind it. There's a classification done, and the rational nexus is that if you don't keep them separately, they might become a threat to the other women in the prison. So that's the rational nexus behind segregating them and keeping them separate. And this is something which they say has been done in the case of, which I don't know, Sana Boyna Satya Narayana versus government of Andhra Pradesh. This is a reasonable classification, right? Okay, coming to the 17th question. Okay, so I think this has to be the easiest of all the questions. Right? There is no rational nexus, right? This is definitely violative. there's no rational nexus as to why would you give chicken twice a week to left-handed prisoners, but you would not give chicken twice to right-handed prisoners. There's no rational nexus, no application of mind. Simple question. Okay, so this is also actually a real case. Madhu Limaye versus Superintendent Tihar Jail, Delhi. अच्छा ऐसा भी हुआ था. अच्छा, Krisha says winner winner chicken dinner, but here they're not the winners, they're just left-handed people. अच्छा, what is the status of PUBG, by the way? Are you people able to play PUBG? All right, moving on to the next question. Question number 18. What is BGMI? घर वाले खेलने नहीं देते. हाँ तो CLAT is coming, so what? You'll not leave all your fun part, ना? हाँ, कैमरा बंद कर रहा हूँ. Yes. Look at this question now. I think this would be the last question, considering that there were 6 questions in the previous 2 passages as well. So a company's employees were governed by the Contributory Provident Fund scheme, which was a state-regulated fund. A pension scheme which was effective on 1st July. However, the employees that had already retired were not covered in the scheme, as they had already claimed all their benefits under the earlier scheme, and this would further also create huge financial burden on the employer. Decide. Okay, so to decide, what is it? This is violative or not violative? Majority of you say that it is not violative, which is absolutely correct. See, the point is that these people have already claimed their benefits. It's not that they are suffering from some loss, right? It's not that the categorization that has happened between class 1 who have retired before 1st July 1978 and class 2 who have retired after 1st July 1978. It's not that one is suffering and the other is gaining. They have received all their benefits and they are being governed by a new rule. There's some rational nexus behind it. So therefore, you can't say that this is violative of any sort. So I think this is correct. Tamil Nadu Electricity Board versus Tamil Nadu Electricity Board versus R. Veeraswamy is the case that they have referred to. Again, so I think that's the rationale. So with this, we come to end of today's session. Thank you so very much for joining in. If in case you have some question, feel free to drop that question in the chat box, and I'll answer them. How accurate are these questions with respect to actual CLAT paper? Whether these questions are easier or the same level? I think these questions are actually on a slightly difficult level. I think it would be, sorry, I need to turn my camera on. So I think the actual paper would be, that is what my expectation is, that, the paper might be a little easier than these questions. But okay, we are anyway prepared for difficult questions and the trickier questions. So I think it would be, it is going to be a cakewalk for all of us coming 23rd July. अरे इतना जल्दी थैंक यू बोल दिया तुम लोग सब लोग, कोई क्वेश्चन ही नहीं है. Is it worth giving ALET? अरे of course, please do give ALET examination. NLU Delhi is worth going to, यार. अरे thank you so much, Krisha. Thank you so much. Weber sir rocks. So the key things, key pointers that I would repeat again. If there's a passage which you have no idea about, which is completely new, skip that passage for the time being. Solve all the passages that you have some idea about. Second, formulate an answer in your head and just find out the options. If you're not very sure of, then go for elimination of options. Third, with all the mocks that you are left with, please make sure that you are using the same pen, you are using face mask, face shield, keeping a sanitizer on your desk while you're taking your mocks. Be prepared for the actual paper that you're going to face on the 23rd. And on the date of the examination, please be at the center on time. Ask your parents to give you travel with your parents. Don't carry cell phones or anything and keep it in a bag or something. Travel with your parents or your guardians, give it to them before you enter into the exam hall. You don't want to be messing around with anything on the day of the examination. You just want to be very clear and focused. And what else? Reach the center 1.5 hours before the entry time. It is okay to go there and wait outside the center than to be late and just miss the examination because there was some traffic or there was some incessant rain or etc., because we don't really know whether they are going to entertain all these requests or not. Generally speaking, on the basis of historical data, they don't entertain any of these reasons, trust me. एक quote हो जाए. Okay, so Harsh, I think I would quote my most famous quote. Hard work wins when talent does not work hard. You may have n number of talent with you, but if you don't work hard, if you're not persistent enough, and you don't give your 100% in these last few days, you're not going to win. So and people who give their best in this last lap are definitely going to succeed and do well. So always remember, an athlete, a field and track athlete, he never gives up at the end, right? They put in all the energy that they have towards the fag end, because that end, Usain Bolt might actually be winning the race, but he still does not stop, or he does not reduce his speed. Why? Is because he's fighting for a world record. So the energy that he puts in to create a world record is something that he's aiming for. So don't leave your preparation. Again, don't be stressed with your preparation as well. Between 2 to 4, you should be solving mocks in these last few days on a regular basis. Do with all the preparation that is required and which you feel is important for you. Yeah, that's it. And just do the revisions. Just do revisions. There's no point learning a lot of new information at this stage now. Pen or pencil in exam, I really don't know yaar. Admit card mein dekho kya hai. What have they said in the admit card? I have not looked at the admit card, so I can't really comment on that. Yes, Nidhi, thank you for reminding. Always remember to manage your emotions in the first 15 minutes. I think this is something which I've, I have always said. The first 15 minutes of the examinations are going to be like a roller coaster. Use the first 5 minutes to, just do some deep breathings and stay calm. Skim through the, paper properly. See what are the areas that you feel are doable, and just take a call as to how you want to go ahead with your preparation in that case. So I think that is going to be very, very crucial as to how you manage your emotions well in the last 15 odd minutes, in the first 15 odd minutes, as well as in the last 15 minutes. So don't get panicky at all. Stay calm. I think all of you are going to do tremendously well. And once you are done with your examinations, उसके बाद तो हम एक बार वापस से मिलेंगे. ठीक है. So I think on this note, I will leave all of you. You have had a good hectic day today, I guess. So I would ask all of you to, just go have a good, nice dinner that your mother or someone at your home would have prepared. Have a good dinner, relax. Just revise certain GK current affairs if you want to before you go to bed, before you retire to bed. And no, I don't think it is compulsory for all of you to get vaccinated. It can't be compulsory even for people above 18 to 45 age, because people are not getting vaccines. So very difficult to make it compulsory for you people. So no, it is not required. It is not mandatory at least. But yes, putting your mask and keeping a face shield is something which is for your benefit only. I would suggest that practice it alongside that, and keep a hand sanitizer always available. A small bottle is going to be crucial for your safety, right? And then we will all meet again once you are done with your once you are done with your examination. What dinner at your home? So I have some good dinner because though I don't live with my mother, but it's her birthday today, so I've gotten some good food to celebrate her birthday all alone. So yeah. Last days we can focus on LR. Just revise. I think it is more about understanding what you're supposed to, or how you're supposed to think, rather than solving a lot. I would suggest that you just stick to revising all the previous mocks. Are, thank you so much. Thank you for your wishes for my mother. Thank you so much. Thank you very much. Thank you guys. Thank you so much. हाँ, मेरा बर्थडे आ रहा है. तुम लोग के एग्जाम्स के बाद आएगा. Absolutely. I'll definitely wish my mother a happy birthday from all of yours end. Thank you so much. And yeah, I think these are the things that you need to keep in mind. Yeah. Okay. So all the very best, everyone. Bringing a closure curtain down to this session, and we'll meet again on say 22nd, one day before the examination, as promised. I will plan something for all of you. Chalo. All right. All the very best. Thank you so much for being here. Wish you all the best. Stay safe and stay healthy. Bye.